Ladies and gentlemen, I'm going to take you on a journey. You may think you are sitting at your desk eating a Pret sandwich. You are not. You are standing at the gates of hell, and I am your impish guide to the arbitration of doom. What horrors await us? We'll begin at the beginning, with the appointment. We shall then consider what happens when the problem is not the tribunal, but the case itself. Thereafter, we descend further into arbitrations that become consumed by their own procedure. And finally, if we have the stamina, we shall reach the award. Because the arbitration of doom has a habit of saving some of its worst surprises for the end. But let's not get ahead of ourselves. The arbitration of doom does not begin at the hearing. It begins much earlier than that, at the moment when the arbitrator is appointed. You picked the wrong arbitrator. That might sound mundane. I'm sure we have all encountered arbitrators who are unprepared, wrong-headed, or just dull. Doesn't sound especially doomy, but it can be rather dramatic. And because I know that part of my job is to keep you entertained while you get your CPD, I'm going to look at some dramatic examples. The first is Allianz and Tonic Star. In that case, the arbitration clause required arbitrators to have not less than 10 years' experience of insurance and reinsurance. One party appointed Alistair Schaff QC, as he then was, of my parish as it happens. I'm sure many of you know him. Nobody questioned his experience in insurance and reinsurance disputes. How could they, really? But the other party argued that the clause wasn't talking about lawyers at all. It was talking about market professionals, underwriters, brokers, people from the market. Mr. Justice Tier, somewhat reluctantly, accepted that argument, considering himself bound by earlier authority. He removed the arbitrator. The Court of Appeal had no difficulty overturning the decision. It held that the earlier authority was wrong, and that legal experience plainly counted as experience of insurance and reinsurance. So the arbitrator was, in the end, perfectly qualified. But by then, the damage was done. Time lost, costs incurred, momentum gone. What went wrong? First, obviously, imprecise drafting. At this point, I should probably give a nod to my hosts. As the Court of Appeal specifically observed, none of this would have happened had the Arias Standard Clause in use at the time been the one the parties picked. It expressly includes lawyers. But the point's a general one. A vaguely drafted arbitration clause can create expensive problems long before anyone reaches the merits. The second problem was assumptions masquerading as agreement. And this really follows from the first point. Both parties thought they knew what the clause meant. Neither tested the assumption. The disagreement only became visible at the point when it mattered. And by that point, there was far too much at stake for a sensible compromise. Thirdly, front-loading a dispute into the tribunal itself. Before a single pleading was served, the parties were already litigating, and litigating hard, about the identity of the decision-maker. That is the arbitration eating itself. There's a second way in which appointments go wrong. So far, the blame has rested with the parties. Sometimes the fault lies with the arbitrator. The arbitrator accepts an appointment that he or she ought not to accept, not because they lack the formal qualifications, but because they lack the distance, capacity, or discipline required for the task. A fairly recent example is H1, H2 against W, D, and F. The arbitration clause required an arbitrator with experience in the relevant industry. What I'm about to say to you may be slightly less surprising if I warn you that the industry in question wasn't insurance and reinsurance, it was film. An industry figure was duly appointed. On paper, entirely appropriate. The difficulties emerged once the arbitration began. The arbitrator knew quite a number of the witnesses. That in itself It's not unusual in a close industry, nor is it necessarily a problem. The problem was what followed. The arbitrator indicated that he would accept what certain witnesses said, and he indicated that before he'd heard their evidence. He suggested that the expert evidence didn't need to be tested. He expressed views on credibility before the evidence had been heard. In short, he treated familiarity with the industry as a substitute for adjudication. You won't be surprised at all to hear that the court removed him. Not because he was dishonest, and not because he lacked experience, at least in the film industry, because he had accepted a role requiring a degree of detachment which he did not possess and could not exercise. This extreme example teaches, I think, a lesson to all of us. It's one about self-awareness. This case happened to involve apparent bias, but self-awareness matters to much more than just bias. When a difficult question about conflict of laws arises in my cases, I can generally solve it. It does, however, require a cold towel around my head and a very, very tedious amount of squinting at Dicey. But I know that. And it's the reason why I'm very cautious about accepting an instruction in a case that turns entirely on some arcane point of private international law. I assume, or perhaps merely hope, that some of my colleagues have similar feelings about other things, maybe when they're confronted with a difficult aggregation problem. Self-awareness means recognizing when a dispute lies outside your core expertise. Some arbitrators, and I'm sure you will have your favorite examples, take an extraordinarily long time to produce awards. If they should die, think only this of them, they bit off more than they could chew. This too is a question of self-awareness. The common thread is the same. Know your limits. Do not accept an appointment unless you can genuinely do the job that the parties need done. So the first stage of the arbitration of doom gives us two distinct failures. The parties may appoint badly, or the arbitrator may accept unwisely. Either way, the result is often the same: delay, cost, and perhaps most importantly, loss of confidence in the process itself. Once the foundations are unsound, every subsequent problem becomes harder to solve. The arbitration of doom doesn't begin with a disastrous award. It begins with what seemed to be a routine appointment. With the obligatory scrap about the arbitrator out of the way, the arbitration of doom continues its descent. Or perhaps it merely shambles onwards. There are zombies here. Specifically, zombie cases. Cases that should have died long, long ago, but somehow continue to consume time, money, and brains. Cases that need a nice, firm shovel to the head, not for their sake, for ours. This is not a new problem. Let me tell you a story. I think it's probably apocryphal, taken from the book of cautionary tales for baby barristers. Many years ago, someone who is now a very eminent silk was a baby junior, so the story goes. He was instructed to attend court to seek an adjournment of a procedural step. Nothing more. He wasn't instructed in the proceedings generally. He wasn't there to argue the merits. He wasn't there to defend the pleadings. He was just there to ask for an adjournment. Unfortunately, the application came before a judge whose reputation for independence of mind was exceeded only by his reputation for impatience. Before counsel could get anywhere near the adjournment application, the judge said, "Mr. X, I've read the pleadings, and I can't see what your cause of action is. What is your cause of action?" This was awkward. Mr. X was not expecting an oral examination on the pleadings. He attempted to explain that he was only instructed on the adjournment application, and the judge was unmoved. "Mr. X, if you can't tell me your cause of action, I don't see why I shouldn't strike out your claim." And then, with admirable efficiency, he did. The claim was later reinstated, so no lasting harm was done. Mr. X survived, the claim survived, the reputation of English justice survived. But the story illustrates an important point. Courts have long possessed mechanisms for dealing with claims that appear, on any view, to be hopeless. Sometimes they exercise those powers rather more enthusiastically than one might like, but they are important powers. Arbitration has traditionally been different. A zombie case could shuffle onwards for years. Everyone might privately suspect it was doomed. Everyone might know how the story was likely to end, but there was almost nothing that could be done about it. That, however, has now changed. Pass me my shovel. Or, at the very least, pass me Section 7 of the Arbitration Act 2025. For the first time, tribunals have been given an express power to dispose of claims, defences, and issues that have no real prospect of success. Litigators might wonder what took so long. Courts have been doing this type of thing for years. Indeed, as our unfortunate baby Junior discovered, they've occasionally been doing it rather too enthusiastically. Some arbitration practitioners might be slightly uneasy when arbitration begins to look too much like litigation. I get the instinct. One of arbitration's great selling points is that it's not court, but this strikes me as being a very clear improvement. A zombie case is not improved by forcing everybody to spend 2 years proving that it's dead. It doesn't become any less hopeless because it acquires 3 lever arch files of disclosure, 4 witness statements, and 5 expert reports. Sometimes it is better simply to reach for the shovel. And now we have one. That brings us to the broader point. One of the recurring themes of the arbitration of doom is that problems become more expensive the longer they are allowed to survive. A defective appointment, a hopeless claim, a procedural error, none improves with age. All become harder to deal with. The zombie cases are perhaps the clearest example. The costs mount, the hearing approaches, the parties become entrenched, and everybody becomes increasingly reluctant to confront the obvious. The Arbitration Act 2025 gives tribunals a new tool, a shovel. The real challenge, as ever, is having the confidence to use it. Unfortunately, not every arbitration of doom can be given an early coup de grace. We descend a little further. The earlier disasters at least announce themselves. You know when an arbitrator has been challenged. You know, or at least have a pretty good idea, when a claim is hopeless. Procedural doom is more subtle. It arrives gradually. The arbitration doesn't collapse, it just slows. At the outset, the dispute is usually quite simple. Some money is owed, some representation is made, some obligation is breached. The parties know what it is they're arguing about. The tribunal knows what it is they're arguing about. Everybody knows what it is they're arguing about. 18 months later, nobody can quite remember. The arbitration has become about disclosure, or timetabling, or experts, or some procedural application that has inexplicably acquired a life of its own, so much so that it becomes application 1, application 2, application 3 as it's renewed every time. The original dispute still exists somewhere, but it's buried beneath several lever arch files and a correspondence chain so old that the opening salvo might well have been sent by fax. The peculiar thing about procedural doom is that nobody intends it. Nobody even really expects it. Every procedural direction is sensible. Every extension has a justification. Every application is arguable. Every step makes sense when viewed in isolation. And yet somehow the arbitration finds itself stuck in the mud. Progress becomes painfully slow. Enormous effort is expended, but very little ground is gained. And everybody starts to wonder how they ended up here and how on earth they're going to get out. Experts are particularly dangerous, I think. In theory, they're there to assist the tribunal, but in practice, they are people, and people bring baggage. Let me tell you about one arbitration, not, I'm pleased to say, an insurance arbitration. My client had instructed expert X. The other side had instructed expert Y, and they fought about everything. Not the important points, everything. Methodology, definitions, assumptions, questions of principle, questions of detail, questions which, as far as I could tell, had no conceivable bearing at all on the outcome of the dispute. I had always assumed that lawyers were the profession most devoted to argument, but I discovered that some experts approach the subject with a degree of enthusiasm which makes our own profession look positively restrained. After a while, it got really rather silly, and I can candidly say I got really rather cross. I called up my solicitor and I said, "What on earth is going on with these two?" I wasn't really expecting an answer. There was a long pause at the other end of the line. "Oh," he said, "well." It turned out that experts X and Y had once been friends. Expert X had introduced expert Y to another friend, Miss Z. Expert Y had hit it off with Miss Z, and they'd entered into a long and apparently happy relationship. Unfortunately, expert Y was concurrently engaged in a long and apparently happy relationship with another woman. Expert X had apparently taken a dim view of that development, and thereafter of expert Y himself. Knowing the history didn't help me to find a solution, but at least when the tribunal suggested concurrent expert evidence, I knew what to do. Given the history, it seemed a bit close to the knuckle. But I digress. The point is not really about experts. The point is that arbitrations have a remarkable ability to absorb human conflict. People arrive carrying rivalries, grievances, histories, and egos. And sometimes the arbitration becomes nothing more than a vessel into which all of these things are poured. Once that happens, the dispute itself can disappear from view. Something that was supposed to be over by Christmas, or at least by the August vacation, becomes attritional. Progress slows, positions harden, costs mount, and everybody becomes increasingly invested in continuing. This is procedural doom. And the difficulty is that there is no equivalent of Section 7 of the Arbitration Act 2025. There is no statutory shovel. There is no procedural silver bullet. No single application which restores everybody to their senses. By the time procedural doom becomes visible, everybody is knee-deep in it. The parties, the lawyers, the experts, sometimes even the tribunal. The warning sign is simple. When the process becomes more important than the dispute itself, something has gone wrong. The arbitration exists to resolve a disagreement. It does not exist to generate fresh ones. If there are any arbitrators in the room wondering what the solution to this might be, I'm afraid to say that I have absolutely no profound answer to give. I generally sit in chambers, read the latest procedural correspondence, and swear softly to myself. But I think the first step to a solution, at least, is recognizing the problem. Because procedural doom rarely arrives with a bang. It arrives one individually sensible decision at a time. One day, the arbitration of doom comes to its end. You have had the hearing. Your opponent is mad. The tribunal are monsters, but eventually it is over. Hollow-eyed, you breathe a sigh of relief. A month passes, then another, then another. You've almost forgotten about it. And then the award arrives with a thud. You pick it up. You read it. You read it again. What on earth have they done? There's going to have to be an appeal. It's like going back to your own vomit. There are so many ways that an award can go horribly wrong. It is really quite difficult to know which one deserves pride of place. The award may be badly reasoned. It may not really be reasoned at all. It might ignore a key issue. It might ignore a key authority. I once had an award which managed to ignore a House of Lords decision that wasn't simply relevant, it was bang on point. After a real agony of consideration, however, I decided that none of these is what deserves pride of place. At least all of these failures are recognizable. You know what has gone wrong. Sometimes the court can even sort it out for you. No. The very worst is not an award that is wrong or bad. It is an award that is pointless. After all of that, the pleadings, the disclosure, the witness statements, the experts, the hearing, the submissions, the waiting, after all of that, you discover that you have very successfully sued someone who is not good for the money. Or perhaps you've got a declaration that nobody really cares about. Or you've won a point that changes absolutely nothing. The tribunal might have produced a masterpiece. The problem is that the masterpiece is utterly worthless. And there is a particular kind of despair that comes from realizing the arbitration worked perfectly, it just didn't matter. In a sense, that is the final circle of the arbitration of doom. The earlier disasters are at least recognizable. The wrong arbitrator, the hopeless claim, the arbitration that disappears up its own procedure. These are all obvious failures. But this last one is, I think, much more insidious. Everything has worked exactly how it was meant to. The pleadings were beautiful. The evidence was compelling. The cross-examination was masterful. The submissions were devastating. And the tribunal went away, scratched its head, and swiftly produced exactly the right answer. The problem was, nobody stopped to ask the most important question. Why are we doing this? What is it that we're trying to achieve here? And will what we're doing actually achieve it? These questions, when said out loud, sound embarrassingly simple. But lawyers are often not very good at asking them, in my experience. When you're a hammer, everything looks like a nail. And when you're a litigator, sometimes everything looks like litigation. We can become so absorbed in the process that we forget the purpose. The claim becomes more important than the recovery. The procedure becomes more important than the result. Winning becomes more important than what happens the day after the victory. And that is how sensible people end up spending years pursuing victories which, in practical terms, are utterly worthless. The irony is that the arbitration of doom rarely begins with a bad decision. More often, it begins with a failure to ask a simple question at the outset. What is success supposed to look like? If that's a question that you can answer clearly, you may well still have disasters, a succession of disasters along the way. But if you can't answer that question, then even a perfect arbitration may prove to have been a complete waste of time. Now, I had left time, quite a lot of time as it turns out, to throw the floor open to questions, or at least to throw the floor open to your war stories. You've heard about my arbitral disasters, and I wanted to hear about yours. But unfortunately, as I understand it, the chat function, or at least the function that allows you to appear to me, is not working. Um, I don't know whether that can be fixed. If it can, lovely. If not, if you have any questions, then I would be delighted to answer them by email or over a call or over a beer. Um, I'll give it a few seconds to see whether or not there is a fix coming. But if not, I will say thank you for listening to me, and I hope you enjoy the rest of your day. Ah, hello. I see that it is working. Let me see whether I can undo this. Hello, I think we have a raised hand from Andrew Bandurka. I think that's, yes. Let's see whether I can see the chat. Andrew, I'm told that you can now speak if you'd like to. Well, I understand that the chat should be working. I can't see or hear you, Andrew, although I see that talking is permitted. So perhaps if you try turning on your camera or at least microphone, that might work. Well, it seems not to be. So we may have to go back to my earlier offer to take questions, comments, and war stories by email or over a separate call or over a drink. Still nothing. So farewell.